Good afternoon, everyone. So today I'm with Council Tobias, Civic Education, and we are going to be discussing Chapter 4 of the Constitution of Uganda, 1995.
Yeah, I'm so happy to be here and ready to deliberate on the Constitution, and we shall learn more as we continue.
So, Council, you're welcome.
Thank you so
Let
much.
us just do, I hope today the thing records well. So,
Mm,
Chapter 4 of the Constitution
yes,
runs from Article 20 to 58.
yes,
And you say this is the title.
that is the title.
And the title is Protection and Promotion of Fundamental and Other Human Rights.
Yes.
Then the question was, how do we have fundamental and other human rights? What's the definition of the fundamental?
Now, if you look at the definition of fundamental,
Mm.
even if you look at the dictionary, fundamental means these are rights that are inherent.
Mm.
So, as a citizen of Uganda, the moment you are born, these are rights that are given to you, fundamental. They can't be given to you by anyone, but you are born. The moment you are born as a citizen of Uganda, that these rights are applicable to you.
You have it. So no need of pleading with government to give you that. That's what I keep hearing Bobby Wine saying, that we cannot negotiate with the government because these are issues of fundamental human rights. We can't bargain about it.
You can't bargain about it. They are not given to you by anyone, but they are inherent.
They are inherent.
Inherent the
So
moment you are born.
I think let me start straight away by reading Article 20, not so?
Yes,
Article 20, the title is Fundamental and Other Human Rights and Freedom.
yes,
Paragraph 1. Fundamental rights and freedom of the individual are inherent and not granted by the state. That's what you just explained.
exactly. Yeah,
They are not granted by the
by the
state.
state.
Then, paragraph 2. The rights and freedom of the individual and groups enshrined in this chapter shall be respected, upheld, and promoted by all organs and agencies of government and by all persons.
Yes, by all people in Uganda.
So this is like saying that all government institutions are supposed to promote, respect these human rights. But we have seen on several occasions reports coming every year that Uganda police and
Mm.
other security agencies are the greatest human right abusers in the country.
I think the police, some policemen are not well um, acquainted with the provisions, and some maybe are not well advised or well thought about the law itself.
Mm.
Because we have seen reports of different human rights organizations coming out saying the police, the main violator of people's human rights. Yet
Right.
everything is provided in the constitution: how you should arrest someone, how you should treat uh, a suspect, when do you use reasonable force in the arrest of someone.
Mm.
However, as we continue with chapter 4, we shall explore more of these rights. The
It's
constitution
always the police.
solely the police.
Okay. Then Article 21, the title is Equality and Freedom from Discrimination. This one has many paragraphs. So
Mm.
the first paragraph is, all persons are equal before the law in all spheres of political, economic, social, and cultural life, and in every other respect, and shall enjoy equal protection of the law.
Yes. Now, that one tells you that every person in Uganda
Mm.
is equal. All people in Uganda are equal. And no one should treat the other as being less, having less
Important.
importance, having less, yeah,
I, I think we
less.
see this a lot when I'm seeing in the political sphere.
Mm,
You'll find that security always, as long as you're publicly known to be a subscriber to Noob, it is like you're an enemy of the state.
And that's why the problem is
And then
because
that's a registered institution.
yes, that's why the problem is because I think police has reached somewhere and it thinks people who oppose the government don't deserve to be secured or protected or the enemies of the state, and that is something they have misunderstood totally. Because if the constitution says all people are equal before the law, why do you treat someone in a different way just because they support a different political party? Indeed, that is totally against the law, and all people before the law are equal,
Mm.
according to chapter 4 of the
I
Constitution.
think this is where we say that during police training, they need to be taught civic education. They need to be taught the constitution more than the physical.
Yes, the government should improve on the ways of training policemen because you can't be training someone only the physical part of it, how to defend, but they are not
Mm.
teaching them what is in the law. Because if government was teaching these policemen different ways how policemen should act
Mm.
and what is in the law, for sure we wouldn't be having these different
Their
cases
motto
of
is
human rights
to keep
violation.
law and order,
Their role is to keep law and order,
and
but not to again punish
I'm sure
the
majority
person
don't
in
know
the
the
government.
law.
Yes, so government should at least put up a school
Mm.
to always at least teach
Teach
them
them.
the law, not only fighting and saving, maybe securing, but teach them there what is in the law and how they should act.
Oh, we start a civic education program to security agencies. You go to police, they organize for you during their muchaka. You first teach them some few articles
Yes,
because it
I
is
think
like
that is the best way of
because
need
it is
that
like
can be
majority don't know the law.
need that can be a good way because yeah,
So
Ugandan police
paragraph
service.
two. So paragraph one was that all persons are equal before the law, irrespective of your political, economic, social, and cultural life.
Yes,
And all of us are supposed to enjoy equal protection of the law.
exactly.
Yeah. So paragraph two. Without prejudice to clause 1 of this article, a person shall not be discriminated against on the ground of sex, race, color, ethnic origin, tribe, birth, creed, or religion, social or economic standing, political opinion, or disability.
Exactly.
I think this one is clear.
So it tells us the different forms of discrimination
Mm,
and which kinds of discrimination are not allowed under Ugandan law.
mm,
So you can't discriminate someone just because of their religion.
the religion.
Maybe because they are Catholics or you are Muslims, now you start discriminating them.
Mm,
You can't discriminate someone
of
because
their
of the
sex,
tribe.
tribe.
So now Baganda, we hate Baganda.
Mm.
They shouldn't, Baganda shouldn't win. Such stuff. So indeed, those different forms of discrimination are discouraged under the constitution.
Okay, that is paragraph 2. Paragraph 3. For the purpose of this article, discriminate means to give different treatment to different persons attributable only or mainly to their respective tribe. I mean their respective descriptions by sex, race, color, ethnic origin, tribe, birth, creed or religion, social or economic standing, political opinion or disability. I think this is an explanation of the word
Yeah,
discriminate,
discrimination.
to give different treatment to different persons.
Yeah. Yes.
Okay. I think we go to the next. The
Yeah.
next paragraph. Nothing in this article shall prevent Parliament from enacting laws that are necessary for implementing policies. I think I'm going to read all, then you explain.
Okay.
Implementing policies and programs aimed at redressing social, economic, educational, or other imbalance in society, or making such provisions as is required or authorized to be made under this constitution, or provide for any matter acceptable and demonstrably justified in a free and democratic society. That is it. Nothing in this article shall prevent Parliament from enacting laws that are necessary for those that have read.
So I think if you read 5, it clearly tells you what the meaning in 4.
In
Cause
4. So I first
instead of
read
telling
5.
you, so 5 is okay. 5 in short terms summarizes what is in 4.
What is
It
in 4?
says government always has the power to amend the constitution in case they find there's a gap or there's something that is needed to be added in the constitution. They can always add it or modify this article. Yes, this article 21.
So 5 is saying nothing shall be taken to be inconsistent with this article, which is allowed to be done under any provision of this constitution, is
Yes.
what you explained.
Yeah.
So we go to Article 22.
Yeah.
So Article 21 was equality and freedom from discrimination.
Yes.
Article 22, the title is Protection of Right to Life,
Yes.
and it has only 2 paragraphs. The first one is, no person shall be deprived of life, intentionally except in execution of a sentence passed in a fair trial by a court or by a court of competent jurisdiction in respect of a criminal offense under the laws of Uganda, and the conviction and sentence have been confirmed by the highest appellate court.
Yes. That is meaning. Actually, that article basically protects the right to life of all Ugandans. No Ugandan should be uh, killed unless it is provided for by the law. However, Ugandan courts have come up and um, changed that position. In the case of Susan Chigula versus Attorney General, court was of the view that the death sentence should be substituted with life imprisonment because court came up and the justices were like, it is so harsh. And the president also came out and said, let the death sentence first be put aside for now.
So currently we don't have a death sentence
Yeah,
in
currently
Uganda.
you don't have a death sentence. If you are sentenced to death,
That's life
it
imprisonment.
is pushed to life imprisonment. Although they are still debating about it for now, but that position is still
Now
the
this
same.
is this is the article where I have issues with, because we saw killings in Kasese.
Yes.
No one was held accountable. We saw killing of November 18th, 19th, 2020 of political. Others were not even political. Like the lady we saw who was from supplying food. One was with a child. 18th, 19th November, there was killing here. No one was held accountable. We have seen killings in Karamoja sub-region. No one is held accountable. And it's always the commanders of those operations are known. And now the constitution here is saying no one shall be deprived of life intentionally. I saw some of government's report on the massacre of 18th, 19th November 2020, saying some were killed by stray bullets, but some were not stray bullets.
And that's why we talked about educating the policemen. Most of these policemen don't know when to act in what way, when to use reasonable force. Because for sure, when people have a right to demonstrate, we are continuing to read chapter 4, we shall find out people have a right to express themselves under Articles 29, Article 38, Article 43. But when people come out to express themselves, usually the police comes out to also act and keep law and order. But when you use reasonable force, excessive force to push away, and I don't think the constitution provides that there's a time a policeman is allowed to shoot and people are peacefully demonstrating. So I think the police has breached
A lot.
that article.
Because you see, for this particular 18th, 19th November massacre, It reached a point where the president confessed that they brought commandos from who were fighting in Somalia to come and face civilians. Oh,
It was so bad.
you see one other thing that perturbs me.
Mm.
These people who were convicted and the president pardoned them.
Mm.
I normally see Balam, the minister for youth, saying
Mm.
these people were burning petrol stations, they were burning tires,
Mm.
they were bombing places, but 2020 is not very far. I don't remember a single petrol station in Uganda that has ever been burned. We don't have that in record. We don't have bombing between 18th and 19th November. We don't have that record. But normally when they are talking, they say these people were bombing, they were burning petrol stations. But the question is, where are these petrol stations? Because we didn't see them, and we have not seen them. A petrol station can't be banned in Uganda, and we are not aware, and it is not on news.
Mm.
So President confessed he brought commandos from Somalia to come and tackle. I remember the late Lokech even told Ugandans that before you go to demonstrate in the street, must write your will. You recall that
Yeah,
scenario?
yeah, I remember.
And yet the constitution is saying no one shall be deprived of life. Anyway, Ugandan things.
So we need to know when to use excessive force when acting.
So I go to paragraph 2. No
Yes.
person has the right to terminate the life of an unborn child except as may be authorized by law. So this is abortion.
Yes. There's cases of abortion, then maybe there is a defense of infanticide, where a woman gets just produced and she's having during that period
Mm.
she's not well. And maybe God can defend her in that.
And also, we made a video about this. Under what conditions one can perform abortion in Uganda, and the laws that uh, 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 how the law condemns abortion,
Mm.
the sentences, and under what specific conditions you are allowed, both by the Constitution, the Penal Code Act, and then we have other international laws
Mm.
like the Maputo Treaty of the African Union. Then we also have other guidelines by by Ministry of Health. We made that video. I think
Mm.
people can watch it. Let me go to the next article. This was Article 22.
Mm.
So I go to Article 23. Article 23. Where is it? Article 23, the title is Protection of Life. I mean, Protection of Personal Liberty. This one
Mm.
you're going to read because I don't have it.
Okay.
Oh, I
Now,
read for you.
now let me read Article 23.
Mm.
Article 23.
But even before we read it,
Mm.
I'm seeing here a definition of the word liberty.
Okay, you can give us the definition.
The definition, liberty, the state of being free within society from
Mm.
oppressive restrictions imposed by authority on one's way of life, behavior, or political views.
Uh-huh. Exactly. So if you read that Article 23, it says protection of personal liberty.
Mm.
Article 23, uh, maybe it's Article 1, tells you no person shall be deprived of personal liberty except in the following, in any of the following, in any of the following. A. In execution of a sentence or order of court, whether established for Uganda or another country, or of an international court or tribunal in respect of a criminal offense. This one is clearly telling us that personal liberty, you have defined the liberty, meaning
A
the freedom
state
of
of,
movement in simple terms.
yes.
So they're telling you when do they um, infringe on your personal liberty? So A is telling us they can restrict your liberty where it's in execution
Of a court
of a
order.
court order. So in case court comes out and says you have committed a crime, or they produce a warrant for you, warrant of arrest. So that will limit your liberty. However, Article 23 talks of protection of personal liberty. So we shall find out. We are now going to see when do they limit your liberty.
When they limit your liberty.
When do they limit your liberty? So B tells us in execution of an order of court made to secure the fulfillment of an obligation. So in case you are supposed to do something and you fail to do it, maybe you are supposed to pay KCCA, rent, and you fail to do it, someone can run to court. Okay, so you can go to court, get an order, and arrest you. C says, for the purpose of bringing that person before court, in execution of an order of a count or upon reasonable suspicion that the person has committed or is about to commit a crime. Preventative arrest.
Preventative arrest.
Yes. So in case they are sure you're about to commit a crime, they have the right to issue your arrest, a warrant for arrest, your arrest.
Or they can restrict your movement at home.
Yes, they
House
restrict
arrest.
your movement. Yeah.
They enjoy doing that.
Remember the case of Chagulanyi Sentamu, Honorable Chagulanyi Sentamu versus I think Uganda. That was 2021 when they predicted that this guy during election period is about to move out and cause a scene. So they had to surround his home. They had to surround his home to prevent commission of a crime. So that means they limited his liberty, his rights of liberty of movement. Yeah. So there is E. In the case of a person who has not attained the age of 18 years for the purpose of education or welfare. So the Children's Act, as amended, also talks about welfare principle of a child. So the welfare principle of a child looks at protecting the rights of children as they are young, the different rights. You know, children are a vulnerable group. So usually it's good to protect them.
So as long as you're below 18, you can be restricted.
Yes, your parent can restrict you.
And it is
something you are going to, which is so dangerous for you.
So your parent can tell you don't reach the neighbor's place, don't go the other side. They know why.
Yeah,
and the law protects
so dangerous for you. But usually this comes out in those children who are under 18 but kinda advanced, like maybe 16, 17. They want to go to clubs, they want to go to those dangerous places. Nyege, things which are mature people. So usually the law protects them in such cases. So there is F says, in the case of a person who is or is reasonably suspected to be of sound mind or addicted to drugs or alcohol, for the purpose of the care or treatment of that person or protection of the community. So in case a person is a drug addict,
mentally unsound.
Not mental unsound. Hey, you can say mental unsound. I think they fall under this. But as long as the person can't control themselves, you're going to go out there, burn someone's home because you are drunk. You want to go out there with a knife and kill someone. Yeah, so in such cases where they get you, arrest you, confine you somewhere, maybe those hospitals.
Like I told you of Mulago.
Yeah, I told you
of Mulago. We call it what? Restraining.
They restrain you.
Yeah, they can restrain you by either locking you in a room or tying you on a bed.
Exactly.
Yeah.
So your liberty is being
restricted
in such a scenario. So H tells us, as may be authorized by law in any other circumstances similar to any cases specified above. So in any other circumstances that where restriction is reasonably needed, someone can go and restrict you. So Article 23(2) tells us a person arrested, restricted, or detained shall be kept in a place authorized. 3 tells us a person arrested, restricted, or detained shall be informed immediately in a language that the person understands of the reasons for arrest, restriction or detention. It's always important. They arrest you, then they tell you why.
You see, that 23(2)
Mm.
of that a person arrested shall
Mm.
be detained in unauthorized place.
Yes.
That's where we talked about safe houses.
Yeah,
They
there
are
always
not
safe
under the
houses.
law, but government is using it a lot. I saw the newspaper of this past week of where they're saying Uganda even has safe houses in Kenya. I'm like, ah.
Imagine.
I
Maybe
saw
they
in
are
the
going to
news.
arrest
I'm
you for a
like,
different
what?
safe house in Kenya. Uganda safe house in
There
Kenya.
was a period when safe house issues here was too much
Mm.
until Parliament had to go and visit even one.
One of the safe house.
Yes, one of the safe houses. There was that period where torture was so much.
Mm.
People were being arrested, taken to safe houses, and members of parliament had to take time and go to visit one of the safe houses. Of course, when they reached there, they were denied access. They even denied that is a safe house. But safe houses are not under the law, and yet they are using it a lot. Then the three were saying, when we are arrested, we have to be informed of our,
You have to be informed of why you are being arrested.
in the languages we understand
It
best.
says a person arrested with 6 shall be informed immediately or in a language they understand the reason of arrest, the restriction or detention. And they're also entitled to a lawyer. So the state can always give you a lawyer, or you can also get a private lawyer for yourself in such cases.
So police is supposed to tell us why they are arresting us,
Yes.
but they normally do.
I don't know.
Uganda
Police,
police, they
Ugandan
know
police
they will
has.
not tell you why they are. In fact, they abduct. I was here used to abduction. They like doing things the mafia way. Anyway, so we are entitled to a lawyer.
Entitled to a lawyer, you are
Here, they will normally not tell you even that you're entitled to a lawyer. They don't. Until when they are taking you to court and you don't have a lawyer, then they assign you that one of the state you have never met, has never talked to you. Like a personal experience, we were once in Buganda Road there. We were for a different case, but there were a group of people who were brought. Is it either and disorderly, something like that?
An offense
And
that doesn't exist now.
the lawyer on the side of the state was forcing them to. I think they had been in remand for 3 months. Was forcing them to accept the crime, not to waste time, such that they can be given less sentence. We're like, now, you have not, these people have never met you because they were coercing them near us. We were the next people after them. These people have never met you. You have just met now in front of court, and the best you're telling them is they should not waste time, accept the crime, such that state can give them lesser sentence. I think that is where they need to over improve. The state lawyers that they are signing to people are not really practicing law. They don't practice law.
They're coercing people into
They just
accepting
want to finish.
charges.
They don't want to know whether you did, you didn't do. They just want to finish the case, which is very, very unfortunate. We go to next.
So, 4 tells us a person arrested or detained. Paragraph 8 tells us the purpose of bringing him, a person arrested or detained, shall be told the purpose of bringing him or her before a court in execution of an order of court. B tells us upon reasonable suspicion of his or her having committed or being about to commit an offense under the laws of Uganda, shall, if earlier released, be brought to court as soon as possible, but in case not lesser than 48 hours. So this is where that 48-hour rule comes in. You should know that the moment you are arrested as a suspect by police, the police has 48 hours to align you before court, for court to mention the offense you have committed, and also for plea. Plea meaning you either plead guilty or not. You have a right to plead not guilty so that the state goes and gets further evidence on your case.
Let me first ask you: if police arrest you, you're in detention, then they bring you before court. Normally,
Yes.
when you plead not guilty, you're remanded. I don't know whether that is the protocol that you must be remanded.
Actually, when you plead not guilty, court, we are going to continue reading this same article. It
Mm.
tells you, after pleading guilty or not, state has the right to say we are still continuing the investigation.
Mm.
But at that same moment, um, you can apply for bail. If court deems it fit, you have the right to apply for bail. So that at least the state can continue its investigations as you are
You're
outside.
outside.
But usually courts, when they look at your bail, maybe forms and your sureties and whatever, and maybe the state objects and says they're going to jeopardize the
Investigation
investigations, usually they remind you for some time so that the state concludes its investigation. But you have a right
to a
to
bail.
apply for bail at that moment.
Okay. Let's go to next. Oh, what?
Hey, now, next is five. Five tells us where a person is restricted or detained, the next of kin of that person shall, at the request of that person, be informed as soon as possible. That is clear. Two tells us the next of kin, lawyer, and personal doctor of that person shall be allowed access to that person. C tells us that person shall be allowed access to medical treatment, including at the request and at the cost of that person. 6 tells us where a person is arrested in respect of a criminal offense, a person is entitled to apply to the court to be released on bail. This is what we have been talking about. And the court may grant that person bail on such conditions as the court considers reasonable. In the case of an offense which is triable by the High Court as well as by the subordinate court, a person shall be released on bail on such conditions as the court considers reasonable if that person has been remanded in custody in respect of the offense for at least 120 days. Meaning that in offenses where you have been on remand, talked
Mm.
of them remanding you after you pleading, they remand you for some time. Now, if they remand you for 120 days in courts below the High Court,
Mm.
you have a right to apply for mandatory bail. Mandatory
Mandatory
means,
bail.
yes, mandatory bail meaning that is bail which must be granted to you mandatory because you have finished all the
You said any court below what?
High Court.
Any court below High Court. When you
Yes,
stay, when you have been remanded for more than
120
120 days,
days.
you have a right to a mandatory bail.
Yes. So if you have been remanded and nothing else has been done on your case.
That's when I told you that we have people in Luzira
Mm,
who have been in remand for 10 years, 8 years,
so much.
9, 15 years remand,
So much.
and no, they don't hear from their families. No one knows where they are.
Actually, I got a case where someone had been on remand for 4 years.
Mm.
That's so bad.
Because
But this
let
happened.
me first ask you, when court remands someone, if court remands you, who is supposed to remind court that there's someone you remanded and has not come
You
back?
see, the problem is most people who are remanded don't know their rights. The relatives also don't know their rights. And most Ugandans are indigent in that they don't have the capacity to have lawyers
Mm.
or to hire lawyers. So, usually when someone is remanded, they think now I've gone. Yeah?
Mm.
They know that they have a right to apply for a production warrant so that you appear in court and your matter is handled. That's why you have so many cases in prisons of people who don't know what next. Be in prison on remand for 4 years because unless a production warrant is signed for you, it's
Mm.
hard for prisons to just get someone and bring you
And
back to
bring to
court.
court.
Yeah. So that's where the issue is.
I get you. Then there's where you read that you have a right to a personal doctor.
Yes,
But we had here a case of Kasango, that lawyer, Bob Kasango,
yes.
who tried several ways for him to be allowed to go for heart surgeries and treatment
Mm,
abroad, and court denied until he passed on in Luzira.
mm.
He tried several times. Experts gave in their recommendations. Court refused. We also saw during the times of Kakwenza when he
Mm.
was sick and he was trying to apply for the same to be granted the right for him to access doctors or hospital. They also denied him. He was a sick man. He was denied bail. He was there sick. Even Dr. Stella Nyans, it was the same. I think
Mm.
we have seen several cases where this particular right here is being denied to for you to see to access private medical attention.
Mm. So I think usually the prisons and police usually violate the constitution, they breach the constitution, they violate people's rights unknowingly or knowingly.
Mm.
Because this is something automatic.
Let me first
Someone is
ask
sick
you.
in hospital, you can't
Let me first ask you.
deny
If
them.
you're sick in Luzira and you want to access your doctor,
Mm.
is it court to give that order, or the doctor can come to Mulago, or the prisons can organize and take you?
Uh,
Because at least for the Kakwenza, Kasango, they were trying through court, and
mm,
court was denying them. I don't know.
it is your right. Actually, as long as you're in critical condition, you can always right to, um, you have the right to a doctor. I don't think they can fail to allow a doctor to come in and examine you. Although prisons nowadays says we have our own
Mm.
facilities that where we handle such patients. That's why it is hard for them to
Mm.
release you from prison to go out for medication because they know when you go out you may either escape or something. Yeah, that's why most people run to court to say let's
Mm.
give this one bail or something so that at least you can get medication from outside.
And court always refuses.
Mm.
Anyway, let's go to next. Oh, it is done.
Um, we are still on
Article
some Article
23.
6, Article 23, 6. Then we are dread. Let's see. We are going to 6B. In cases of offences which are triable by the High Court as well as by subordinate courts, the person shall be released on bail on such conditions as the court considers reasonable if that person has been remanded in custody in respect of the offence triable before trial for 120 days. This one we have handled it. So we are going to see in the cases of an offence triable only by the High Court,
Mm.
the person shall be released on bail on such conditions as the court considers reasonable if the person has been remanded in custody for 360 days before the case is committed to High Court. Now, I can give an example of these, the FDC, the 36 FDC
Cut.
prisoners
Mm.
were arrested. They are arrested for a case of terrorism
From Kenya.
from Kenya, moreover. So they deported to Uganda
Mm.
and charged with terrorism. These guys were in prison for I think 3 months,
Mm.
but their case is supposed to be handled by High Court.
High Court.
Because prison can't be handled by magistrate court, it's a lower court. So the role of the magistrate court was to commit them, just reads your case and commits you. So you have a right to apply for bail in the High Court.
Mm.
Yes, before court hears your case, so that you be coming from outside. So this is what this fee is telling us, that as your case is being committed to High Court from magistrate, that we
Mm.
can't handle, it is a High Court case. During that procedure, you can apply for bail in the High Court that you are temporarily released as you
Come
handle your
from home.
case.
But in case you're remanded for 300, what?
360 days.
There, you also have a right to the mandatory
Yes.
bail. They
120
said court
days,
below,
lower court.
lower court is 120 days.
360 days is when your
High
case is
court,
committable to High Court. Yeah, 360 meaning 1 year.
1 year.
Yeah. So we have
Then we saw these political prisoners of no to almost
March,
4 years in
4 years.
remand. Several attempts to
Once.
bail were refused. They
That's
reached a
so
point
bad.
and even denied them access to lawyers.
That's so bad because for me, I know where the problem was. It's because I don't know why they failed to accept their bail. They're pretending, these guys will escape, these guys will interfere with the investigation,
Like
and
Olivia
they can't.
Lutaya, they
Yes,
said she had nowhere to stay.
nowhere to stay. Where is she now? Where is
Ah.
she now? So some of these things, these are political games.
Political.
These are political games.
Ah,
So 23/7 tells us a person unlawfully arrested, restricted, or detained by any other person or authority shall be entitled to compensation from that other person or authority, whether it is the state or an agency of the state or other person or authority. So, in cases where you have been arrested and detained, and maybe your rights have been violated, you're entitled to compensation from the state. Yes, you're
that
entitled
one
to
is clear.
compensation from the state. It is as well a person is convicted and sentenced to a term of imprisonment for an offense in a period that he or she spends in lawful custody in respect of the offense before the completion of his or her trial shall be taken into account in imposing the term of imprisonment. Meaning that court should always
Mm.
reduce the time you spend on remand. So if your offense takes 10 years, court has that obligation to always remove those
The time you have spent in
days.
remand.
Yes, those days or years you have spent in remand. That's why this is no political prisoners. The moment they pleaded guilty, court deducted the 4 years. That means they're supposed to be in prison for almost 7 years. But since they're 4 years, court removed the 4 years,
And sentenced them to 3 months.
3 months, which were later pardoned. That's how Uganda.
The way shame has disappeared
It's
in
so
the
much.
current system. Anyway,
So much.
we go to the next.
8 tells us where a person is convicted and sentenced. Mm, where a person is convicted and sentenced to a term of imprisonment for an offense in a period she spends in lawful custody. I think you have read this. The next one is the right to an order of habeas corpus shall be inviolable and shall not be suspended.
Habeas corpus.
Habeas
That's
corpus.
you
Now
said that's
let's try
the
to get the definition of the habeas corpus before we continue.
habeas corpus.
Yes, habeas corpus. Now habeas corpus literally, but I want to just first define it legally. Habeas corpus. The dictionary tells us the meaning of habeas corpus.
Mm.
Uh, okay, basically, habeas corpus means that these are in instances where someone has not been brought before court.
Mm.
Maybe you think he's missing, or there is another reason why he's not being brought to court. You have a right to apply for a writ of habeas corpus so that he's produced in court.
You said it's a rate of
Habeas
habeas
corpus.
corpus. Rate you said is WR.
WRIT. You apply to High Court for writ of
I saw
habeas corpus. Produce them before court.
they did the same for Chibalama. Up to now, we have not seen him.
Yeah, the instances where government
Even
hides.
even after the prime minister
Mm,
at one point confessing, they have him. He was arrested for, is it murder of police officers?
exactly.
They applied for that. He has never been brought, and yet there it is saying that it shall be inviolable.
Inviolable.
That once you apply for it, it must be.
Someone has to be produced before court, and court listens to their matter. Now, uh, I've got the definition of the dictionary.
Mm.
Dictionary tells us habeas corpus is a legal process that allows someone to challenge their detention or imprisonment in court. It is an equitable remedy by which a report can be made to a court alleging the unlawful detention or imprisonment of an individual. Unlawful detention or imprisonment. Because for if you have sent on remand or you have, Ugandan operatives, security operatives, who just come and capture you, they take you without you knowing where you are. You people don't know where you are. But when people are sure it is the police that the person, so they can always file that application in court, so that court orders the police
to
to
bring
bring
you.
that person. Yeah,
Then you
to
can challenge your detention.
your detention.
Uh,
That's why that Article 239 is telling us it is inviolable. You can't suspend it. People have a right to apply for it.
so if you have a relative who has been put in prison and you don't know why they have been in remand, you try following up, they are not being brought to court, you can apply for this
Yeah, a writ
and they
of
will be
habeas
brought.
corpus. A writ of habeas corpus.
Isn't that the last part of
Yeah, we
Article
can go
20?
to
So Article 24,
24.
that one now I have it. The
Mm.
title is Respect for Human Dignity and Protection from Inhuman Treatment. And it has one paragraph, not so?
Mm.
No person shall be subjected to any form of torture or cruel, inhuman, or degrading treatment or punishment.
I think this one is so clear,
It's good.
protecting people from such forms of treatment, torture,
Torture.
cruel treatment, inhuman
But,
treatment.
but the way we are seeing it happening, and it's still by security, because at least there are examples I can name.
Mm.
There's this particular man called the Maiga Ronald,
Mm.
Omunyarwanda wa Bobby.
Mm.
His story was aired by NTV, was aired by, is it BBS Terefina?
Mm.
The one who was alleging he was given punishment by sodomy from CMI, and at one point even the lady heading Human Rights Commission denied knowing him, yet he has taken there several complaints to human rights about that particular issue because he was tortured.
Mm.
His story was made public, but the head for human rights during one express that was hosted by Solomon,
Mm.
she said she has never heard of him. She doesn't know about him, and he was so broken. That is one. Then there are other stories. The peaceful march to parliament. There are protesters who were tortured from Uganda Road Police. Zake,
Mm.
who was tortured and at one point dumped in front of hospital, and they claimed he had escaped, yet he couldn't even move an inch. We have
Mm.
seen torture on Robert Chagulanyi Centum. I think we have seen a lot of stories of torture.
Actually, people have a right to apply to court
They always
as long
deny.
as you are sure your rights have been violated. That's why it's good to always master.
Mm.
If you can get the names of the officers who treat you in such a way, cruel ways, torture and all that,
Mm.
can always
Sue them.
sue them individually so that they can pay for their. Because the police also has the disciplinary committee, all that,
Mm.
those things that deal with discipline of officers, and they can always be taken out of service and also be imprisoned. I've seen instances where policemen are captured on TV caning border guys.
Mm.
Yeah, as long as something can be proved, they cannot be punished. At the end of it all, however, torture is condemned.
Article 25.
Article
I
25.
think torture is too much. That one we cannot even finish it if we start.
It's too
But
much.
always police will come out and deny, the army will deny, CMI will deny, like this particular man who was paraded by Kulaije,
Mm.
who was burnt with flat iron because he
Was
was
burnt
from
in the
the,
front.
yes, that one who was from their own detention, burnt with flat iron. Kulaije paraded him, and then they accused Noop that Noop is the one that burnt them, and they have the person saying Noop banned him, but they didn't arrest anyone from Nook. Then after sometimes the guy comes out saying he was promised to money and cash and all that to speak that. But the story of torture in Uganda is too rampant, because at least if you take a look at Kakwenza, by the time he was running into exile, at least he took photos and we saw how his back was,
Uh,
because
yeah, I
he
remember those
was
pictures. I
accusing the
remember those
first
pictures.
son of torturing him to that extent. Because if you see how Kakwenza's body was, the story of
Because
torture in Uganda,
I remember those pictures.
the
I
story
remember
of torture.
Kakweza won a case against the police.
Yes, he recently won a case against them and is being compensated. Is it 50 million for all
Which he
that
has
torture?
rejected.
He has rejected. Of course, now it cannot change anything,
Yeah, it can't.
because that ruling, they agreed his rights were violated. He
Mm,
was tortured, but they are rewarding him, but they are not punishing the ones who did the crime. In fact, they didn't even talk about them. Let
mm.
me go to Article 25.
You can read.
Article 25 is, the title is Protection from Slavery, Servitude, and Forced Labor.
Mm,
Then we saw the definitions of forced labor. I read it.
mm.
Maybe I start with servitude. Servitude, the definition is the state of being a slave or completely subject to someone more powerful. That's servitude. Then labor. This definition is according to International Labor Organization, that is ILO.
Mm.
First Labor Convention 1930, number 29. It says that forced labor or compulsory labor is all work or service which is exacted from any person under the threat of a penalty, and which the person has not offered himself or herself voluntarily.
Meaning, in cases where someone hasn't given their consent to work and you use any other force to make them do something, the exceptions in that article,
Mm.
but where you force someone to do something unwillingly is a
Forced labor.
violation of their rights
So
under
I
that
start with
article.
1 under Article 25. No
Yes.
person shall be held in slavery or servitude. Is
Mm.
clear.
Yes.
Number 2. No person shall be required to perform forced labor. We have read the definition of forced labor.
Yes.
For the purpose of this article, forced labor does not include A. So they are telling us things that appear to be forced labor, but they are not forced labor.
Now there they are trying to tell you,
Mm,
yes, things that appear to be forcible, but they are not.
they are not.
So maybe you can read for us the different things.
The different ones. A. This is Article 25, paragraph 3A. Any labor required in consequence of the sentence or order of a court
Mm.
is not forced labor.
Yes. In case court tells you you are sentenced to
Community
community
service
service,
is
that
not
is not
forced
forced
labor.
labor, as long as under the law.
B. Any labor required of any person while that person is lawfully detained, which, though not required in consequence of the sentence or
Mm.
order of a court, is reasonably necessary in the interest of hygiene or for the maintenance of the place at which the person is detained.
Um, Now, for cases of people in prisons, tell you clean the latrines,
Mm.
go and dig. Although people are challenging it, we the lawyers are trying to do something about it because you can't tell someone detention to go and dig for the whole day.
Mm.
Telling people to go and dig for the whole day just because the constitution tells you,
No,
as
there's
long as
that
someone
digging.
detained.
Yes, there's that digging of you cleaning the compound. I think that one is under this.
Yes, there's killing, but there's that harsh.
There's digging to for prisoners to be taken to Salim Saleh's farm, because
Uh-huh.
for the period we were in Luzira,
Mm.
they were like, now rainy season is coming.
for you to
Salim
make.
Saleh is about to begin farming. They'll come here to pick people. We were like, what? So prisoners are being taken to farms of big men in government to go and do farming. I don't think that falls under this.
So they used to tell people that rain is coming.
Hey, when we were there, they would be there very worried. They are like, now rainy season is coming. Salim Saleh is about to start farming. They will come here to pick us. We are like, eh.
Too much.
So, but here they are saying for those activities of cleaning where you stay is not
Yeah.
forced labor.
Where I stay, sweeping,
Mm.
yeah, anything done under the authority, because obviously you can't be in that environment.
Mm. Then C, any labor required of a member of a disciplined force as part of that member's duties. As such, or in the case of a person who has who has conscientious objections to service as a member of a naval, military, or air force. Any labor which that person is required by law to perform in place of that service is not forced labor. I go to next.
Yeah.
D. Any labor required during any period when Uganda is at war or in case of any emergency or calamity which threatens the life and well-being of the community, to the extent that the requiring of the labor is reasonably justifiably in the circumstances of any situation arising or existing during the period or as a result of the emergency or calamity for the purpose of dealing with that situation.
Now, for example, in cases of, remember the COVID times,
Mm.
those days, they could, actually, first part of me on that.
This one they are saying any labor which is required during any period when Uganda is at war.
Oh, it's at war.
Is at war, or in case of any emergency or calamity.
I think they're saying in cases where, let's take for Russia versus Ukraine, there's a war and they need your backup. We used to remember World Wars, we studied about World Wars. Yeah, so in case where the state needs you
to join the army,
yes,
and fight for the country,
they can come for you
and you have to
for your labor. It's not to be taken as first labor.
Okay, then E is saying any labor reasonably required as part of reasonable and normal communal or other civic obligations is not forced labor. I think that's Article 25, and it is done, isn't it? Then we can go to Article 26. Article 26, and the title is Protection from Deprivation of Property. One is saying every person has a right to own property, either individually or in association with others. So even women can now own property.
Actually, people have an issue with that. Remember those old customs that you said women can't own property, women can't inherit, women can't do anything. Yeah, so that article came in to defend the rights of women, to show that a woman can do something for their country. They have rights on property. Yeah, even disabled people, the different categories.
Every
Own
person has a
land,
right to
own,
own
yeah, all
property.
kinds of property. So that article defends them.
I think that one is clear. You don't even
Yes.
need to add.
Yes.
2 is saying no person shall be compulsorily deprived of property or any interest in or right over property of any description, except where the following conditions are satisfied. A. The taking of possession or acquisition is necessary for public use or in the interest of defense, public safety, public morality, or public health.
Yes. So that one is meaning that in cases where, so the example I was giving you, public health, COVID
public
times.
health, COVID time.
Yes. So
Uh, Public use, government wants to put a hospital.
yes, wants to put a hospital. Government wants to
Defense,
do something. Maybe they want to put up a defense on the borders. The land can be taken to
Iran can be taken.
cover up.
So
You
they
see,
can
there is
deprive.
what they call compulsory acquisition of land in
Mm,
law. So compulsory acquisition comes in where something is needed in those different forms you have read.
mm,
Government can come up. It gives you the notice. We need your land. This
mm,
land for this and this. If you agree, they will compensate you. They have
mm.
a duty to compensate you because they will bring up a value while you have a chairman's meeting. They
It's called
check
compulsory
everything
acquisition of
of
land.
land by government where land is needed for something, and they say there's no way we can do this thing without you. So they will compensate you. If you want land, they'll give you another piece of land. Now, for the case of, I looked at NTV News yesterday.
Mm,
There's that case of the wife, the widow of General Rwanda.
mm,
She owned a very, I think General owned a large piece of land somewhere around
mm,
there, either those Western countries. So these people have been using the land for burial as a burial ground. So she had started telling them to transfer the
mm.
different graves and all that. So government had to compulsory acquire the land from her. They met up, they decided, let's buy off this land. For we shall give you the 3 billion, but
Let
let's leave
people.
the people use it as a burial ground. So that's when
Mm.
those are the different occasions when government can acquire your land compulsory. Yes.
So they are saying, I continue.
Yes.
They are saying B in B, 2B is saying the compulsory taking of possession or acquisition of property is made under a law which makes provision for there's I, prompt payment of fair and adequate compensation prior to the taking of possession or acquisition of the property. And this is two, a right of access to a court of law by any person who has interest or right over the property. I think you explained this one,
Yeah, I've
that you have
explained.
to be compensated promptly and
Yes.
adequately.
That's,
You have explained that one. So, as much as government has that provision for compulsory taking of your land, they must
compensate.
compensate you adequately and promptly.
Yes. Look at
And they are saying in the last one that a right of access to a court of law by any person who has interest or right over the property is also clear.
yeah, someone has to be compensated. As long as
Mm,
they're taking your land, because people have different land rights,
mm.
have registered land, so there's always that right of compensation.
Article 27, right to privacy of a person, home, and other property.
Yes.
I see it has only two paragraphs. Number one,
Mm.
no person shall be subjected to a unlawful search of the person, home, or other property
Yes.
of that person.
Meaning that no one has the right to come and
Search you.
bombard your house, search you without any maybe any other thing authorizing him to search you illegally. You have a right to privacy.
Mm. So unlawful search of of a person, home, and other properties not
Yes.
allowed. Then B is saying unlawful entry by others of the premises of that person is clear.
Exactly. Unlawful entry.
Entry,
You don't have a search warrant or something.
don't enter.
Just come and trespass on my land or my house or something.
Then
It's
two is saying no person shall be subjected to interference with the privacy of that person's home, correspondence, communication, or other property. So you shall not be subjected to interference with the
mm-hmm.
privacy of your home, correspondence, communication, and other property.
Yes.
I think this one is clear.
It's kind of clear. Protection of rights to privacy.
So Article 27 is prohibiting unlawful search of a person's home and their property, prohibiting unlawful entry to their premises, prohibiting interference with their privacy of home, communication, and other property. I think it is clear, but the way people, the way they break this particular one,
Usually police coming in with a
they
search
come
without,
without such warrant.
without a search warrant. And then there's search without a warrant
Mm.
in the Criminal Procedure Code Act. In instances where someone may change something,
Mm.
yeah, they have that search. But it's always told to use reasonable force in that. So you can't come out and destroy someone though you break unless someone refuses to open up.
To open up. But
Yes.
in Uganda, I've never seen a case where they have used the search warrant.
There are those incidents they use them.
Mm.
Just that you can't always publicize it.
So we are going to the longest one, Article 28, right to a fair hearing.
Actually, Article 28 talks of what constitutes a hearing. How should a hearing be conducted?
Mm.
Yeah,
So we just start it straight away because for it is long.
yeah, you can.
Article 28, 1. In the determina- that in the determination of civil rights and obligation or any criminal charge, a person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law.
Exactly. Meaning, every person that appears before court has the right to a fair hearing.
Fair
Any
hearing.
type of court, tribunals, not tribunals usually, those are small courts,
Mm.
court martial, what, all that, those different small courts. So they have a right to fair hearing. Wherever they appear, they have the right to that hearing.
Fair, speedy, and public hearing.
Exactly. Speedy.
So it must be fast. Not
Speedy.
this one here where we are saying Human Rights Commission was having cases filed by
That's
Robert
handling one case
Chagulanyi.
per year. That is
From
the age
2018
against
to
a lot.
2024, you haven't initiated a
Yes.
process.
One case per year. It is so,
One case per year.
imagine, one case per year.
Our human rights is a clear example of a failed institution.
Yeah, for sure it has let people down. Now that people have lost trust in that commission.
So they are saying even the hearing should be public, that it shouldn't be hidden.
Yes.
Then I go to 2. Nothing in clause 1 of this article shall prevent the court or tribunal from excluding the press or the public from all or any proceeding before it for reasons of morality, public order, or national security.
Yes. So it should always be in a public. It must be a public hearing.
Then 3. Every person who is charged with a criminal offense shall A. Be presumed to be innocent until proved guilty or until that person has pleaded guilty.
That is meaning by the time that they are arrested,
Mm,
or they are saying you were a suspect or did something,
mm.
you are still innocent. Until the state proves contrary, they bring in evidence to show that you are guilty. That is what they call the right to a fair hearing. You are not guilty until proved guilty,
Until proved guilty.
and you have no case to answer. At the end of it all, if you are not guilty,
But here in Uganda, once you are arrested,
they automatically think you are guilty.
you're guilty. It is you to prove your innocence.
No, it is not the same. According to the law, it's
In
different. It is
Uganda,
applicable, but the police usually takes it as long as you arrest this person
is guilty.
is guilty. So by the time courts give their rulings and know that you have suffered enough, like
Let
a
me
guilty
go to
person.
B. So B is saying, be informed immediately in a language that the person understands of the nature of the offense.
Yeah, courts have the right to always tell you the nature of offense, which offense you are being charged of,
Mm.
Yeah, so that you can either plead guilty or not.
C is saying be given adequate time and facilities for the preparation of his or her defense.
Yeah, they should always give you ample time
Time and
to prepare
facilities.
defense.
If you don't have a lawyer, they have to provide you.
Yes, if you don't have a lawyer, the state always has that duty to give you a state lawyer.
Mm.
Yeah, usually on state brief, so they give you a state lawyer to handle your work.
Then D, be permitted to appear before the court in person or at the person's own expense by a lawyer of his or her choice.
Yes, that's right.
This one is clear. So you
Mm.
can appear in court as person or your lawyers can represent you. But last time you told me not for all cases. Some cases
No,
you
you
have
can
to.
try to go in person,
Mm,
like represent yourself. But usually in such instances, where you represent yourself,
mm.
you have less chances of winning. Because for you are just talking ordinarily without the
Eh,
law, using common sense. Yet you need to use the law when you are fighting the law and facts. You need the law and facts as you are
Need
talking.
the lawyers.
So you need a lawyer by all means. So it's your right to always request for a lawyer,
Mm,
or you get one from the
from
state.
the state. Then E is saying, in the case of any offense which carries a sentence of death or imprisonment for life, be entitled to legal representation at the expense of the state.
Yeah, exactly. Those capital offenses, in cases where you don't have a lawyer, you have killed someone. So you can the state lawyers are always there
Mm,
to defend you. Those are paid by government.
mm.
So government can just assign a lawyer, let him do pro bono for you in your case. A lot of people don't trust state lawyer. How do you start
People,
against the state and
yeah, the
getting a
state
state
is
lawyer?
prosecuting you,
Yes.
and in,
So
uh,
usually people don't trust.
let me first ask in this particular E, where they are saying in the case of any offense which carries a sentence of death or imprisonment for life,
Hmm.
be entitled to legal representation at the expense of the state. So if I have a private lawyer, the state
Hmm.
will not compensate him.
No, private is you have not decided to go in your own pocket.
That
Yeah.
means there you need the state lawyers. Then
Yes.
it is unfair already.
Yeah. Usually people can't trust state lawyers because
You can't trust them.
it's like this no they know
Mm.
what were that were pardoned.
That
They were forced to use state lawyers.
the state is prosecuting you and you're using.
State lawyers.
eh,
So they were forced to use state lawyers in order
is
to
very
base their
unfair.
own.
I think that is one of the most unfairest game now.
So
So you're prosecuting me, then you're also giving me a lawyer to defend me. So F is saying be afforded without payment by that person the
mm,
assistance of an interpreter if that person cannot understand the language used at the trial.
mm. So I think this is a must. A court must always have an interpreter, a clerk.
Mm,
Usually clerks do the interpretation part of it. In case you're a Munyankole
mm,
and you are before court, you don't understand English. They can't always put a case upon you without you knowing what they're charging you for. So they bring in these interpreters to translate
mm.
to you what they are saying in court. So that is also right. You have a right to interpret.
Then G, this is Ferrigier, is saying
Yeah.
be afforded facilities to examine witnesses and to obtain the attendance of other witnesses before the court. If be explaining, let me first check that thing
Okay.
because we
What
might
are
be.
you put for me? Yes. Okay.
You can be explaining that one.
So,
that you must be facilitated to examine witnesses,
Mm.
and that the witnesses must be given to you before
Have you paused this?
court. I've not paused. That's why I said you be explained.
And you
There's no power.
it is not bad.
This small rain and power is gone.
Oh God. So you can pardon me of that.
It is be offered facilities to examine witnesses and to obtain the attendance of other witnesses before the court.
Yeah, so they give you time to organize yourself.
Mm.
Organize your submissions, organize your witnesses. If possible, if you say there's a witness who is who is not in court, court will always adjourn to give you time.
Mm.
Because they look at a fair hearing. That's what you're looking at, fair hearing. When what constitutes a fair hearing? A right to give your own defense.
Mm.
So they give you time to get enough witnesses for yourself.
So this is 28, paragraph 4.
Mm.
Nothing done under the authority of any law shall be held to be inconsistent with a clause 3a of this article, to the extent that the law in question imposes upon any person charged with criminal offense the burden of proving particular facts.
So they're trying to say the burden is always on the states to prove. They have said you have committed a crime. It's always the state to prove those facts that indeed you committed.
So that is where the presumption of innocence.
Yes, presumption of innocence.
Then B,
So it's called the burden of proof.
burden of proof
Yes,
is supposed
so
to
it
be on the
is on the
state.
state to prove.
Then B, clause 3G of this article, to the extent that the law imposes condition that must be satisfied if witnesses called to testify on behalf of an accused are to be paid their expenses out of public funds. That
If what?
is saying nothing done under the authority of any law shall be held to be inconsistent with clause 3G of this article, to the extent that the law imposes conditions that must be satisfied if witnesses called to testify on behalf of an accused are to be paid their expenses out of public funds. And 3G is this one we just read, to be
Mm.
offered facilities to examine witnesses and to obtain attendance of other witnesses before the court.
Mm. It means witnesses always have to be given enough time to
To prepare.
to prepare. Okay.
Because here I'm saying they are saying if these witnesses are going to be paid their expenses out of public funds, they must meet this condition here.
Be afforded.
G, to be afforded facilities to examine witnesses and to obtain the attendance of other witnesses before the court.
Mm.
So that means the facilities also include those things of transport expenses for the
Mm.
witnesses.
Yeah, they have to. If the state has decided to take on the case, then they need to do everything.
So if your
Cover up
witness is
everything.
coming from Guru, the
They'll have to
state pays.
compensate.
Uh,
Because it's going to come for free, not on your expense.
so five is saying with that except with his or her consent, the trial of any person shall not take place in the absence of that person, unless the person so conducts himself or herself as to render of the continuance of the proceedings in the presence of that person impracticable, and the court make an order for the person to be removed and the trial to proceed in absence of that person.
These
Unless
are hostile guys. If you are hostile, you are not choose and you are so hostile, court can say, let him not come in court,
mm,
let him be on the screen. Let's use now the court
but beyond
system.
that, your trial must happen in your presence.
Yeah, yeah.
Uh,
Yeah, usually even in cases where someone is maybe sick, you can look at this recent case of this guy in High Court. This ongoing trial where they accused is always on screens and what.
Mm.
Yeah, that's system. In cases where you are harsh, they say this one let him be in the prison, but him
You
just be appearing through.
through screen.
Yeah.
So 6. A person tried for any criminal offense or any person authorized by him or her shall after the judgment in respect of that offense be entitled to a copy of the proceedings upon payment of a fee prescribed by the law. So when I undergo through trial, I have to be given a copy of that proceeding
Yeah, good
after me
proceeding.
paying, because I'm seeing
I think
here.
court has that court fee where you just pay for the ruling, the judgments. Yeah, or else they tell you
Mm.
go and photocopy it yourself.
So this is in case you want to do an appeal. What?
Yeah, for appeal,
You
records
read
of
through.
appeal. Yeah, you apply for record of appeal either from the chief magistrate or the registrar. So, want records of this case, want to appeal, you have filed maybe a notice of appeal.
Mm.
Yeah, so
So
can easily give you that.
7. No person shall be charged with or convicted of a criminal offense which is founded on an act or omission that did not at the time it took place constitute a criminal offense,
Yes, meaning the law does not act backwards
but forward.
but forward. So, if for you today you killed someone, tomorrow the law is changed that if you kill someone, you're not imprisoned. Meaning people will kill people tomorrow want to be imprisoned, but for you, you'll be arrested and imprisoned.
Mm.
So meaning the law works forward, not backwards. So whatever, if you committed a crime today and the law is today like this, people are arrested for murder, they'll be arrested. If it changes tomorrow, you can't claim the law is not the same like
Eh,
yesterday.
I get you. So 8. No penalty shall be imposed for a criminal offense that is severer in degree or description than the maximum penalty that could have been imposed for that offense at the time when it was committed.
Yes, exactly. Meaning that if today you committed murder, they tell you the penalty, death. Now, people committed murder. I think before the Susan Chigula case, which came in and said if you committed murder, you're supposed to be taken for life imprisonment instead of death. Now, they also committed murder before the judgment in that case were supposed to be killed. So you can't claim now, since they changed it, how it can defend you. So meaning that if your penalty was different from the current, by the time you committed the offense, they will consider the law which was standing at that time.
Mm, and it must not be severe.
Yeah, it might not be so.
Okay. 9. A person who shows that he or she has been tried by a competent court for a criminal offense and convicted or acquitted of that offense shall not again be tried for the offense or for any other criminal offense of which he or she could have been convicted at the trial that for that offense except upon the order of a superior court in the course of appeal or review proceedings relating to the conviction of acquittal.
Meaning that if for you, you have been convicted, charged, you have been charged and convicted of this offense of maybe treason.
Mm.
So someone can't again bring it up somewhere else. Yeah, you committed treason for that same offense.
Mm.
Because now they've already settled a judgment for it. They can't come back to that same offense
You
to again
cannot.
try you. Yeah.
Mm. So 10. No person shall be tried for a criminal offense if the person shows that he or she has been pardoned in respect of that offense
Yes.
like the
And
current the
they not
the,
don't
no,
do abandon.
the political prisoners.
They are so free.
That's why I say again that Sanya needs to be told that there's nothing government now can do.
Yeah.
They have made you accept the offenses, they have
And they
charged you,
abandoned you.
and they have pardoned you. They have it in record that you were convicted and pardoned. So even if they tell you to abuse Nope and you refuse, they can't take you back to prison. But I think he was told, in my opinion, I think he was told if he doesn't do those things, he will be taken back. Maybe he's just not aware.
They're scared.
Maybe
But that article protects.
it protects him
Yeah.
that no person shall be tried for a criminal offense if the person shows that he or she has been pardoned in respect of that offense. Then 11, where a person is being tried for a criminal offense, neither that person nor the spouse of that person shall be compelled to give evidence against that person.
Yes. Now these are instances where maybe they know how your wife knows the truth. Bring her as witness
Wait,
against you.
so your wife is not supposed to be
She can't
to
give it.
testify against you?
Yes. She has that protection
Mm.
unless she willingly does it.
Where a person is being tried for a criminal offense, neither that person nor the spouse of that person shall be compelled to give evidence against that person. So they cannot be compelled, but they can voluntarily come up.
Voluntarily give it. I can't bring it to court, they arrest you, they want so that you give evidence.
Mm.
You knew. Usually women, that applies usually to you. That protects.
So 12, that except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it prescribed by law
Yes, no person
shall be
convicted
convicted.
of an offense unless the
The
offense
offense
is
is
provided
defined.
for in short terms in the Penal Code Act. Because the Penal Code Act is like the act that provides for all offenses. All offenses. That's why when they get you committing something, police will have to look through the offenses. Not police.
Except for contempt
Which
of
charge should we
court.
give this person?
Mm.
They send it to
Mm.
state, they lost it and all that. So they always get the offenses. But they can't convict you of an offense which is not in the law. Can't
like
always forge an offense.
common nuisance.
No nuisance. Common nuisance, I think it's a new offense actually. Again,
This man.
I think there's so much people doing.
Even they
Common
arrested
nuisance.
MPs, the likes of Semuju, and charged them with common
Common
nuisance.
nuisance.
Like, how do you charge a member of parliament?
It's so weird.
Eh?
It's so weird.
Someone said, how do you charge me, a member of parliament,
Being a
of
common
being a common nuisance? And I saw, is it the speaker? Someone said that it does not matter whether you're educated or an MP.
mm,
There is a point where you can act as a common nuisance. I'm like, this country. So, Article 29,
mm,
we are done with 28.
mm.
Article 29, the title is Protection of Freedom of Conscience, Expression, Movement, Religion, Assembly, and Association.
Yes.
1. Every person shall have the right to a freedom of speech, expression, which shall include freedom of the press and other media.
Yes. Meaning you have a right to speak out in case of anything.
Mm.
You have freedom of speech.
Speech, expression,
Yes.
uh, which include of the press and other media. Then B, let us finish chap. B,
Mm,
freedom of thought, conscience, and belief, which shall include academic freedom in institutions of learning.
mm,
Freedom of thought, conscience, and belief.
mm.
So you can't dictate how someone thinks,
No.
what
As
they
long as
believe
they
in,
believe in something, they can have that right to speak out. And,
which include academic freedom in institutions, which I think right now is being so much suppressed in Makerere, in my opinion. There's a
yes.
lot of academic freedom
Students come out to say we are
suppression.
not being paid to suspend them. Really, that is not.
We even saw during the period of corruption allegations against the speaker, where is it a law school of Makerere brought it as a question in one of their papers, and the administration tried to suppress, and the public came up, and then they tried to
Why?
so there's that suppression of academic freedom in institution. Then C is saying freedom to practice any religion and manifest such practice, which shall include the right to belong and in the practice of any religious body or organization in a manner consistent with this constitution.
That is the freedom of religion.
Of
People
religion.
can practice a religion they want.
You can be a witch doctor, you can be a born again.
Actually, yeah, this.
Then D, freedom to assemble and to demonstrate together with others peacefully and unarmed, and to petition. And E, freedom of association, which shall include the freedom to form and join association or unions, including trade union and political and other civic organizations.
These are usually.
So you have freedom to assemble,
Yes,
to demonstrate peacefully unarmed.
As long as you feel your rights are being filled, you have the freedom.
Freedom to join
Assemble
political parties, associations, trade unions. This rain here. This rain has spoiled everything. Then 2 is saying every Ugandan shall have the right A, to move freely throughout Uganda and to reside and settle in any part of Uganda. B, to enter, live and return to Uganda. And C, to a passport and other travel documents. That is 29. Then 30 is the last, right to education. All persons have a right to education. Stops
Yes,
there.
right to education. You have right to study.
This rain has spoiled.
At the university.
And I think that is enough. That is article. That is article 30, chapter 4 of the Constitution. I think we shall continue with other parts of chapter 4. For now, we can pause in this one.
Okay.